Good morning, Your Honors. May it please the Court. Rob Hockman for petitioners.
Could you speak up a little bit? I'm having a little trouble hearing you.
Let me try that. Is that better?
That
Very
is
good.
better. Thank you.
This case arrives in something of an odd posture. The Department has pushed aside the arguments that were hashed out before the trial in appellate courts. The bulk of the briefing before this Court concerns arguments by the Department and by the State that, in our view, are not properly before this Court. Speaking frankly, I think that's because the issue that is properly before this Court is relatively straightforward. So I'm going to begin with that question. Whether the application of this Court's settled retroactivity standard to the Unclaimed Property Act changes at issue in this case permits retroactive application of those new rules. Then I'll turn to the Department's main argument, its request to redirect that standard simply towards determining legislative intent. And finally, I'll address the State's especially late arriving request to abandon due process limits on retroactivity entirely. Now, I'm not going to say anything else about our waiver arguments today, unless you have questions.
Well, but let me ask you on that point. You're here as the appellant. They're here with the advantage of having the judgment below in their favor. And they're simply advancing a variety of reasons to uphold the judgment below. And we have this tipsy coachman thing that says even if the court's reasoning was wrong, if there's another good reason that we can know that's just supported by the record, then we can uphold it on that basis. So why I don't understand how a waiver operates and given that array.
Yeah, understood, Your Honor. And I think what I'd say to that is, when you're talking about changes to a settled standard, I don't think waiver is simply a mechanical process that's triggered by specific acts, although it can be. But I think when you're talking about a standard that's been in place for decades, like the retroactivity standard of this Court, it's been unquestioned for decades by members of this Court. Then I think if there's going to be a change, I don't think you should do it in a case where in the courts below, that standard was agreed to and endorsed by both parties. Normally, you'll see it's true. The District Court of Appeal doesn't have to resolve the question when two reasons are put before. It doesn't have to evaluate both. But usually, in those kinds of circumstances, at least the argument was presented, the parties are aware, the issues have been illuminated, and that's just not the case here. That's just not the case here.
Could I ask you, counsel, so I'm not sure that I agree with you about how settled the standard is, and even if you think it's settled, sort of how it applies here, but whatever that standard is, it seems like it is the servant of the text, that the standard is not the law, the Constitution is the law. So I think that we need to understand the standard in light of what the law is. So could you please, as precisely as possible, tell us what is the life, liberty, or property interest that you have been deprived of in this law? Sure,
and I know that, so this turns to the I think this actually is related to the standard, Your Honor, because I don't think the standard is quite as divorced from the Constitution as the other side makes it sound. So the standard in Miranda Holmes is due process protects individuals from retroactive application of a substantive law and the first one is adversely affects or destroys a vested right? And I think, there are the other two. We think all three are ticked off in this case. But the important point is we do not concede away that we lack a property interest at issue here.
Okay, but your briefing is focused on the middle.
So I'm going to focus on that right now. But we do think we prevail on the other two issues. I just don't want that to get lost. So here's the way insurance works, right? The insurance business involves insurance companies taking their assets and investing them in a pool of assets. It's all commingled, right? And it's our assets. Those are our assets. When somebody comes forward with a claim, we have to take money out of those assets and pay. We have an interest in those assets. We have an interest, a property interest, in those investments on a going forward basis. That interest is heavily regulated. How we structure that is heavily regulated. The department signs off on all of that.
I'm sorry to interrupt you. So it seems like that stuff at most relates to the escheat part of this. So let's start with the two. Let me ask you, hold on, the search and contact stuff. Those just completely relate to arguably sort of facilitating the bargain that was struck. You know, people pay their premiums when they die. If everything's set up properly, they submit a claim, they get paid. So explain to me how whatever interest you might have in what you were just describing, how is that affected by a statute that essentially helps the parties, you know, carry out what the actual contract was?
Because actually, first of all, under the Thrivent case, the parties aren't actually carrying out what the actual agreement was. And this is what's...
Hold on, let me ask you about that. So this law does not change, the beneficiary still has to submit the claim to be paid, correct? I'm not talking about your interaction with the
Actually,
state.
no, Your Honor. No, I don't think that's quite right.
Where in the text of the
what the
new law
rules
does it
provide
change that?
is
So tell me if I'm wrong. The way I understand this is just about, on the company's end, identifying people who potentially have died, communicating with potential beneficiaries. The beneficiaries still have to follow whatever the contract says.
That's correct.
About how you get paid.
Of course.
Correct?
Of course. But the difference is, and the reason why Thrivent is relevant, and this relates to both the escheat obligation and the search obligation, the common root of all of this is the trigger of the obligation to pay. And this is what affects our property interests, the pooled assets.
Hold on, but so it seems, the argument, it seems like what you have put forward is that you have a property interest in the state of regulation that existed at the time that the policy was entered into. And so if there was no law at the time that the policy went into effect that required you to communicate a certain way and to do these searches to see if people were dead, that essentially that, you know, any new quote unquote obligation that's put onto you, that's a completely regulatory obligation that doesn't change what you owe people or when they are entitled to get paid, et cetera. It seems to me that what you're saying is that you have a right in the continuation of that regulatory regime throughout the life of that policy. Am I wrong about that?
Well, there's two answers.
On the search and contact.
Two answers to that, Your Honor. One, that's actually, I don't think that's a property right. I think that's a liberty interest, because the search obligation is not, you know, they make it sound like,
so
you know,
tell
you hit
me,
but I think there's also a property interest
I have
there.
looked far and wide, and I have not seen a single case anywhere that describes that type of expectation as a legally protected interest. If anything, I see tons of cases, state and federal, that say that essentially when you're in a heavily regulated area, just business in general, you do not have any kind of vested interest, protect property. I know that the vested interest thing can be circular, whatever, but the point is, if you're trying to identify legally protected, legally recognized interests that have to be balanced against a state interest, I haven't seen anything that suggests that you're entitled to be locked in to that regulatory regime.
Yeah,
Can you tell me a specific case that helps you on that?
I'm going to tell you the case that I think is most clearly controlling in this situation. It's Menendez. And this is where I've been trying to get to, that you can look at this case from the point of view of the search obligation. We'll do that going forward. The earlier trigger is what's key here. The earlier trigger is what both affects our property interest and our liberty interest. And let me explain, right? In Menendez, right, you had a change in the rule, a pre-suit notice requirement that basically extended the window of time when a payment obligation was triggered. Right? It changed that window of time. Until a pre-suit notice is given, the insurer can still wait to pay, and then ultimately when the pre-suit notice comes, you've got 30 days or whatever, I don't remember exactly, I think it's 30 days, to pay. This court said that change in the timing of payment was substantive. And if it's substantive to delay the timing of payment, again, because their insurance companies make plans, make big investment decisions, structure their investments, all with a view to the timing of payment. If it's substantive to delay, surely it's equally substantive to accelerate the timing of payment. And
you're talking about the payment to the state of money.
No, I'm talking about the payment both to the policyholder and the state.
No, but I mean, I thought that we had established that someone still has to be dead, right? You don't have to pay before someone dies, okay? The beneficiary has to submit the claim paperwork to you, upon which time you pay them. Yes. So as I understand the payment part of this, nothing about the relationship between the beneficiaries / policyholder and the company has been changed. The only thing that's been changed is what happens with this stuff that we're calling unclaimed property.
What's been changed for the policyholder is the policyholder rights under the thrivent old rule, under the old statute. We issue the policy and we stop. And when somebody comes to us, we pay. That's our obligation. We satisfy it repeatedly over and over and over. Under the new rule, when the policyholder writes the policy, now we can't do nothing. Right? Now we have to start doing things.
Right.
And even if we fail to do anything, under the old rule, if we fail to do anything and nobody comes to us and tells us of a death, no penalties, no fines, nothing happens. There's no legal obligation that's triggered.
So
right? Under your theory, as soon as the
can I ask you a question?
Sure.
I'm sorry. Is your theory that if the state passed a law that said, and let's assume that the baseline is there's no requirement that you communicate on this subject on a basis with your policyholder. If the state passed a law that said you need to send a letter to all of your policyholders every year that reminds them to tell their beneficiaries, when I die, you're going to need to submit a claim, et cetera, et cetera. It seems like on your theory, that would be a due process violation because it would be imposing a new quote-unquote obligation onto a previously completed transaction. Is that wrong?
No, I don't think that's our view. And that's because, again, everything operates off the payment trigger. That's what affects our property interest. As soon as the policyholder dies, under the new rule, nobody does anything. Now, a portion of those pooled assets have to be dedicated, are no longer ours. They're effectively, they become the policyholder.
Let me clarify something for my own purposes. The property that you're referring to, is it your argument that the claims process is part of the contractual agreement that you have with the policyholders, and the statute has substantially altered the contract in a way because of substantially affecting the claims process?
I mean, you could call it the claims process, but I think that what's critical and what really helps to understand this is that it's the trigger of the payment obligation. Here, the payment obligation trigger is death, not notification of death.
Is that your argument, or is it that you're affecting, the statute has affected the property, that's the money that you're holding, the benefits itself that's ultimately to be paid to the policyholder?
Both, Your Honor. It's both.
Well,
both.
The idea, which it seems like it's, what's your argument? You're protecting both?
Well, maybe I misunderstood your question then. Could you restate it?
What is the heart of the due process argument? I mean, it seems like if the claims process is being impaired, I mean, I know you had an impairment of contracts claim that you dismissed, but it seems like if your argument is that the claims process is part of the contract, is being impaired, that seems like an impairment of contract argument.
All of this was true of Menendez too, right? I mean, this is why I keep focusing on Menendez. That's a total change in the process. It's a change in the trigger of the payment obligation that led this court to the conclusion. Wait a minute, you're delaying. This statute delays the obligation to pay. That is a substantive rule that impacts.
So is it that you're having to do more and that the statute's affecting the claims process, or is it that you're having to pay out the money earlier than you used to?
So the having to do more is a liberty interest, and the having to pay sooner is a property interest. And so I think in both respects then, the Constitution is implicated. And that's why it's substantive.
There's no case that says that there's a liberty interest in not being told by the government to communicate with your customers or to do the search. But let me ask you, under the existing unclaimed property law pre these amendments, there was a trigger that went into effect if the company had notice of the death, I'm assuming other than through the submission.
If we came to know.
If you know.
Right,
so,
if we know.
I mean, so it seems like this is really just a modest tweak to that in the sense that it's essentially facilitating you knowing about it. I understand you have to do things, but I could understand that there would have been much more of a change from the baseline if there had never been anything like that, and if the law clearly said that until this magic, claims form arrives and, every I is dotted and every T crossed, there's no trigger. You're not a holder of someone else's property. It's your own property. It seems like this is really, the principle has already been established that it's not necessarily the submission of the claim that converts this into property that you're just holding. And so how is this not just sort of a modest tweak to that?
Yeah, well, for a couple of reasons, Your Honor. First of all, searching the DMF for policies that go back decades and decades and decades, they make it sound like, and it certainly seems like, I understand the intuition that it's simple. It's a simple
You
process.
already do it for annuitants, right? When it inures to your benefit.
Yeah, well, except we do it for annuitants when it's important to make sure that we're not making payments erroneously. And two, this is the other thing that's critical about that, when we know and we have the information to do it at a reasonable and low cost. What this statute does is it imposes upon us a huge obligation that's going to have to be carried out manually in a lot of cases, because you're talking about policies that go back decades, long before there were databases. When you're talking about annuities, we can set up a system that makes it easy. And for what it's worth, going forward, we can plan for this. It's going to be costly. We'll do it. We'll price policies accordingly. But what this statute does, is it basically says, going backward, you have to treat policies that you haven't prepared for this kind of obligation, you haven't prepared for this sort of expensive search obligation, and the costs of that absence of preparation for which you had no notice, the costs are all going to hit at once.
Yes.
And that's a huge problem for insurance companies that have to plan out.
Let's say we agree that it's a huge problem for insurance companies. I think the question I heard in your colloquy from hasn't been answered. What's the case that tells us that you have a liberty interest from being protected from this problem? Operating in a competitive marketplace involves cost. It involves surprise costs, regulations that you perhaps didn't anticipate. What's the case you can direct us to that tells us you have a liberty interest not to have to respond to such changes? Because I don't know that case.
Well, again, I think that the real core issue here is we have the property interest in the payment trigger, because that's what we plan for. That's how we actuarially account for our long-term obligations. That's what the regulators look at when we make our investment decisions, when we set our reserves aside. And what happens is when you change the payment trigger, again, just as in Menendez, you change the payment trigger.
Why is it that an impairment of contracts case? I mean,
As
opposed to due process.
This court said it's both, quite clearly. And in fact, the impairment of contracts issue was treated in a footnote and sort of set aside.
And that would
Right.
be you got a facial challenge here. That would be a as applied argument, right?
The impairment of contracts issue would probably be difficult to raise as a facial challenge, whereas this argument is straightforward as a facial challenge.
So an as applied due process in this case, you think is essentially the same as an impairment of contracts case?
No, it's a facial challenge. The due process
I
argument is
understand, but if you brought it as applied, it would be essentially the same arguments.
It would certainly overlap, which is exactly what this court said in Menendez.
In Menendez, though, the payment that you're talking about was it was the direct relationship between the policyholder and the company, and the court focused on the fact that under the status quo you were due money on day X, and then it became day X plus whatever.
Mm-hmm.
Just please answer this clearly.
Mm-hmm.
As I understand it, as between the policyholder and the company for this law, nothing has changed about that payment relationship. What has changed potentially in some cases is when you have to send this money over to the state because it's been deemed unclaimed and the 5-year recapture period or whatever it's called has lapsed.
But what has also changed?
Can you just answer that, please? Has the payment relationship between the policyholder and the company changed?
The payment relationship has changed because we now have to go out and every year check every policyholder, check and see whether any policyholder
That
has
has
died.
nothing to do with the timing.
And then
Does
tell
that
them.
does it have anything to do with the timing of when you owe the money, in the sense of the person has to die, a claim has to be submitted, and then you guys send the check? Has that
Certainly,
changed
after
at
we
all?
reach out to them, they have to say, yep, that's right, here's the death certificate, please pay us. That's certainly true. That's certainly true. But what's changed in the relationship is now they're the ones who don't have to do anything, and we're the ones who do. And we come to them. And that's a big change. And that's a big change affecting the actuarial calculations, the planning that went into setting our reserves and setting up our investments. Remember, our investments are short, medium, and long term. If we have to sell investments early, we take a loss. And when you bring in, and this is what's very important about insurance, the way it works is we can actuarially predict over time the flow of payment obligations. When you enact a statute that changes that flow in a specific way for what are admittedly under this court's settled law, passed over transactions. The transactions are done when the insurance agreement is executed, right? And you change that flow, and you all of a sudden create a spike in payments. Now you've affected our property interest in the the heavily regulated structure of insurance.
And I understand this. Don't take any of this as a criticism of how you've done your business before, but you essentially planned for ignorance as to people, whether they were alive or not. I mean, the pre-existing unclaimed property law said, notwithstanding any other provision of law, if the company learns of the death of the insured within 4 months after the death, the company shall take reasonable steps to pay the proceeds to the beneficiary. So, you planned that with all the models, I'm sure it's a science, you can sort of predict people not submitting claims on time and whatever, but essentially, I'm just not aware of any time that a court has recognized that as a protected interest.
Two responses to that, Your Honor. First, there is no planning or expectation about anybody not telling us that they've died. What we are planning on, what the actuaries do, is they look at the flow of claims. They look at the flow of claims.
It's the same thing. You're assuming that there's going to be a certain number of people who aren't going to submit claims.
And then there's something we didn't plan for that's very important, which is the DMF, searching the DMF. That's not a simple process, as I was explaining a moment ago. That's a huge expense. Another one that we didn't plan for and didn't calculate into our flow of payments because it wasn't an obligation of ours to do at all with respect to any of these previously executed policies. We'll plan for that going forward, but having to do that now, all at once, especially with respect to policies for which we have exceedingly limited information, some for which we have exceedingly limited records, is not just a huge expense, but a major disruption to our property interest. And the liberty interest with respect to that, Your Honor, is, again, if we had known that we were going to have to do this, we could have set up the record keeping in a way that would have facilitated this. Instead, we're stuck having to take a modern database and match it up with punch card system, and other older technology.
Could you help us? So, one thing that this case I think will have the effect of doing, however it turns out, is to maybe get this court to be reflective about what the actual standard is in the law. And so I know that you've characterized the test as being settled and all that, but we also have the Knowles case where the court explicitly says that that the test, and it cites McCord, that it's not to be applied absolutely, and it says that courts traditionally focus on three factors: the strength of the public interest served by the statute, the extent to which the right affected is abrogated, and the nature of the right affected. It seems to me that, and this is derived from this Hockman Law Review article that kind of goes through, I don't know if there's any relation. It seems to me that if you apply that test, and this isn't a criticism, it's just it's devastating to your position. It seems like the only way you can win is if we convert the constitutional rule into this three-part thing and we apply it in this very literalistic kind of way. But could you respond to how, if we clarified our law to just apply the Knowles test, could you help us understand how that would apply to your case?
Well, first of all, I don't see anyone really advocating the Knowles test.
Okay, I'm asking.
But assuming that there's a balancing that would have to take place, I still think we prevail. Again, because what's at issue here is not going forward, right? It's not a going forward interest. It's a reaching back interest. You're talking about a really small percentage of total policies But when you group them together and you squeeze them together, and you make payment obligations arise suddenly all at once, some of which, by the way, because the statute requires payment for a partial match unless we disprove death at the relevant time, some of which is going to involve payments to the wrong that shouldn't be paid. And you group them all together and you impose that obligation on insurance companies all at once, and then I think you're talking about a situation where the public interest is small and the interest on the insurance industry, the impact is pretty large. And of course, it folds back in because the interest in the public, in the insurance companies being able to meet their obligations over time,
I'm sorry,
is
though,
pretty
but
substantial.
Could you clarify, because this gets back to what we've talked about before. What I understood this 717 to be doing was affecting when you might have to submit money to the state as unclaimed property. If you haven't gotten a claim, or if you have doubt as to whether the match is correct, the payment wouldn't be going to the beneficiary. Am I wrong about that?
That's wrong. It's a partial match. We have the burden to disprove. So if we can't disprove.
Where in the new law does it say that?
So the new statute imposes the obligation on us. This is at 717, 8 and 9. Paragraphs 8 and 9, Your Honor. And what there is that creates a statutory presumption of the obligation to make payment. This is why I keep focusing on the payment trigger. It's even on the basis of a partial match. Even on the basis of a partial match. And then it creates also a statutory shifting of the burden of proof. Now we have to disprove death. We have to disprove death. So yeah, they're going to, in a world where it's unclear, this is a big deal. And this could have a big impact. And again, that's why it matters so much to our property interests.
Counsel, we are running through your rebuttal time here.
Yeah.
And I know you want to have some rebuttal time. So but we've helped you run through it. So I'm going to, if you can keep going.
No.
But what I will still afford you the 8 minutes rebuttal.
I appreciate that, and quite frankly, I'm perfectly happy to have spent more than my time answering your questions, because that's what I'm here for. So thank you for your time, and I appreciate the alert.
Mr. Chief Justice, and may it please the court, I'm Joe Jaco, here with Ken Bell, representing the Department of Financial Services. Florida's Due Process Clause reads, "No person shall be deprived of life, liberty, or property without due process of law." Petitioners rely solely on a due process claim to facially challenge the retroactive application of the 2016 changes to the Unclaimed Property Statutes. Yet petitioners fail to assert the Act's retroactive application would deprive them of any constitutionally protected property interest. Petitioners argue that if the 2016 Act's retroactive application, quote, imposes a new obligation or duty in connection with a previous consideration, that alone is a due process violation. That's incorrect, and petitioners misapply this court's precedents.
Counsel, can you, in the best way that you would do for your client, distinguish our case law in Miranda and Menendez?
Absolutely. Let me start, if I may, Your Honor, with Menendez, since petitioners say that that is the case that is controlling here. Menendez came up from the third DCA as an impairment of contract case. And the reason why it did, and that's stated on pages 875 to 876 of the opinion, of the Supreme Court's opinion, is that the PIP statutes in Florida are incorporated into the policies. So if there's a change in the PIP statutes, there's a change in the policy. And thus, you would have an impairment of contract claim. That was assumed in Menendez. So the question in Menendez becomes, how do you then apply the two-prong test? The first prong of that test is if the statute has clear legislative intent to apply retroactively. Menendez said it does. Miranda Holmes says it does. In this case, there's clear legislative intent to apply retroactively. So that's all the same. The first question of that two-pronged test is statutory interpretation. Is the statute substantive or remedial? In Menendez, the court found that the statute is substantive, and they found that based on whether it affects prior rights, obligations, the Miranda Holmes test that they cite. In Menendez, the court cites Lafayette, they cite Landgraf from the U.S. Supreme Court. All of those are questions of statutory interpretation of whether an act is substantive. So basically, if I can say it a different way, Your Honor, is there's three balls being juggled here. There's three necessary components to find a constitutional violation: clear intent, whether an act is substantive, and whether the act violates a constitutional provision. In Menendez, it had clear intent. We knew that it would have an impairment of contract violation because the PIP statute's incorporated. And so the whole issue in Menendez is the statute substantive? Miranda Holmes, three balls. One, clear intent. We have that. Then the court goes through assessing, is the statute substantive? The court finds it is, because it affected a vested right. That is the substantive test that Miranda Holmes lays out. Once the court determines it's substantive, the court goes on and says, is there a due process claim at issue? There is. A cause of action is a property interest. So once the court marries the fact that it's clearly intended, that it's substantive because it affects vested rights, and a property interest, then you would have a due process violation. In this case, you've got clear intent. That's assumed. But the two balls that are still in the air is it substantive versus remedial? The first DCA said it's remedial, so the test ended. If we even assume that the statute is substantive, there's still a remaining ball, there's still a remaining test, and that is there a property interest to violate the due process clause? Petitioners have neither a property interest, and we would argue, as the first DCA found, the act's not substantive. But if it is substantive, even assuming, they still don't have a due process claim.
I guess to put a finer point on the liberty interest, one of the things you said in your very helpful discussion of Miranda Holmes is that a cause of action can be a property interest. How would you respond to your colleagues on the other side when they say, if they said, well, what we're losing here is a cause of action, that is, a potential claim to claw back money that is improvidently paid in the case of a mistake, right? In one of the circumstances that we were discussing just a few moments ago about, an inconclusive, death master file, payment where the evidence is unclear. We make the payment. It's an error. I would, I guess, have an action for replevin or some other cause of action to get that back. Isn't that a sufficient property interest to meet that last leg of the Miranda Holmes test that you were talking about?
Yeah, thank you, Your Honor. So, first of all, petitioners said they have a property interest in the payment trigger. The first DCA said that the parties agree there is no property interest here. So, I think this argument has been waived. Certainly, petitioners have never brought up a liberty interest. I think that's waived. But even assuming they claim a property interest, the question of whether there's a property interest was settled in the U.S. Supreme Court's decision in Connecticut Mutual, where they said that funds that are held in owing are not the property of the insurers, right? That's the property of the beneficiaries. And, Your Honor, what they argue here is that because the statute imposes a new obligation, it is unconstitutional. That's not the proper constitutional test. The proper constitutional test is, first, does it impose a new obligation? That's statutory interpretation. Is the act substantive? And the reason why that's important is because there's a presumption against substantive acts. So only when the legislature clearly intends, then when it's found to be substantive, and then when it finds a specific constitutional violation. In your hypothetical, whether that would be a property interest or not, is a question of, as Justice Muniz says, a potential balancing test. We're not arguing here how this court should or shouldn't determine a property interest. What we're arguing here is, one, that's a separate test from whether the act is substantive, and they never allege that they have a property interest other than the fact that the act is substantive.
I think to be fair to the other side, I mean, our cases have not done a good job of explaining what this test is, where it came from, how it's supposed to be applied. But could we just clarify your position on this payment obligation? The way I read the statute, all of this, checking the file and the presumptions and everything, that all relates to when the trigger starts for the 5 years and when the money would have to be paid to the state. Am I reading that right in the sense that it does not change the conditions under which money has to be exchanged between the insurance company and the beneficiaries? The beneficiaries still have to submit a claim, and the company can do whatever due diligence it wants before it sends the check, et cetera. And that the unclaimed property law does not regulate that payment relationship.
Your Honor, it is true that the unclaimed property law doesn't affect the policies, right? So what was contracted in the policies is not changed by Chapter 717. What Chapter 717 deals with is that once there's a death of the insured, then what happens to the money? Right? Does it get paid out to the beneficiaries? The new statute says that there's an obligation to go in and enhance your records, right, to check the death master file to identify that death. But the fact that it's due on death, that the payment goes out to the owners of the property, the beneficiaries, hasn't changed.
And it doesn't override. I mean, if the policy said, we're not going to write you a check until we get the right form and you surrender the policy and all that, that is not overridden by the changes to 717.
That's correct. 717
Okay.
only.
It just affects when the 5 years starts to run and when you might have to write a check to the government, not to the policyholder or the beneficiary.
That's correct.
Well, isn't the claims process, wouldn't you consider that part of the obligations the insurance company has to its policyholders? That's part of the agreement, right? Isn't that part of the actual agreement that exists between them?
Well, whatever may be, Your Honor, in the contract, the 2016 Act did not change the provisions in the contract. It's not like the PIP statute where the legislature has replaced the common law tort principles and privileges with a statutory remedy.
I mean, there's a lot of bad faith actions brought on the failure of insurance companies to properly process claims, right?
Sure, but
So there's a duty that's actually owed by the company to the policyholders that has to do entirely with the claims processing process.
That's right, Your Honor. But petitioners never bring an impairment of contract claim here. As you mentioned, they dismissed it, right? So they're not arguing that somehow the 2016 Act changed or impaired that contract. What they're arguing is that there's some unfairness here in the fact that the rules of the road have changed, right? That the statute has changed.
I mean, I could see that. It seems like that if you have a statute, which I think they're arguing here, that substantially changes the whole dynamic of how claims are to be processed, and it puts much more obligations on them than ever existed before, and actually impacts the timing of how the money is to be paid. Aside from what the responsibility is on the policyholder, now the insurance company has responsibilities according to the statute. So the dynamics really, it seems, have changed, but it seems like the facial argument here that they brought is that there's no way that any insurance company could ever have a different claims processing agreement. So it seems problematic from a facial challenge, it seems to me.
That's true, Your Honor. I mean, there are several bases upon which I believe this court can reject what petitioners are seeking. One is the fact that they bring only a facial challenge. Two is the fact that the court could agree with the first DCA that the statute's remedial. But even if the court finds that those changes were substantive, right, that they changed the rules of the road, that maybe even they're unfair, petitioners still have to find a specific violation of a provision in the Constitution. And they don't have that. They don't have a property interest. All they say is that our property interest is if the statute imposes a new obligation. But this court's precedents have never agreed with that. Under Miranda Holmes, there was a distinct cause of action property interest. Under Menendez, impairment of contract, this court has never found a retroactive application to be unconstitutional without three things: clear intent, substantive, and a specific violation.
Well, is it fair to say, though, that we have, I mean, it seems like we have recited a test repeatedly that if you just sort of mechanically applied it, it might, as a matter of just of language, apply here, but that we've never applied that test to facts like these, to an interest like this. That it would be, I mean, in my view, it would be an expansion of what we have done in the past. I mean, Menendez, whatever you think of it on the merits, at least it's kind of purporting to look at this, the PIP feature being written into the contract. It's purporting to, you know, point to the interest that you have in, you know, access to attorney's fees and all that, that are sort of, you know, it has a flavor, even though it doesn't use the label, it has this flavor if you've got some kind of property interest in that. It seems like what we have here is a pure, the interest that's being asserted is just the interest in the regulatory status quo going on throughout the life of the policy. And as far as I know, we don't have any case that has applied the test and found it violated in that context.
Yes, certainly there isn't a case from this court that finds a property interest in the expectations of the law, that the law won't change in terms
Or a liberty interest in not doing and not communicating with your customers.
Absolutely. If I may address a few additional points, because petitioners again say that Menendez is the controlling case here. I mentioned that on pages 875 to 876, the court recites Article 1, Section 10, which is impairment of contract. So that was the assumed constitutional violation. They've mentioned in their brief footnote 4, and I think it's illuminating because footnote 4 is to Lafayette. Lafayette is a statutory interpretation case on whether the statute was substantive. So what footnote 4 says is that in addition to finding a statute that might be substantive, and if so, the presumption against retroactivity applies, so the act would apply prospectively only. Another method to find whether a statute applies prospectively only is to find that it's unconstitutional, which would be in Menendez, Article 1, Section 10. Lafayette is cited by petitioners for their case, but Lafayette deals with an interesting issue in which the legislature passed a statute in 1992 to, quote, reaffirm the original legislative intent of a 1982 statute. And what the court said is that's a nullity, that a subsequent legislature, without amending the act, just commenting on the act, gets to change what a 10-year-old statute's legislative intent is. The court found that it's the court's role to interpret the law, and rather than assuming some kind of post hoc, false, clear intent to comment on a 10-year-old statute, the court looked at the statute afresh. And it found that the 1992 statute indeed had a substantive effect on the 1982 statute. So Lafayette is only a statutory interpretation.
I mean, I don't know if I agree. I mean, Lafayette essentially said that it was a penalty, that it was turning conduct that would have been legal, not bad faith, not, you know, subjecting you to liability into something that did. And the interesting thing about that case was that they tied the trigger to the accrual of the cause of action, not to the issuance of the policy, which I think we haven't really even gotten to it, but I think that there are some interesting issues in this case as to whether how retroactivity as a concept even applies here. But I do think that the other side has the better argument on whether Lafayette is a case where the court is applying a substantive constitutional prohibition. I think that what they said there was that it was, you know, that the law change essentially penalized the defendants for conduct that was in the past that was, you know, not sanctionable when they did it, and then retroactively was punished. Is that wrong?
Your Honor, Lafayette never reaches a constitutional question. I mean, Lafayette never found the statute to be a due process violation. What Lafayette does is it applies the presumption. The reason it applied the presumption is because it found first that the legislature's clear intent was post hoc false intent because it only commented on this 10-year-old statute. It didn't amend the statute, right? And so once the court dispensed with the clear legislative intent, the court then applies the statutory presumption. That presumption comes from, Supreme Court cases that we cite in our brief, particularly Landgraf, which I think explains the presumption in depth, both in the majority opinion and in Justice Scalia's concurrence. And the presumption is the statute's found to be substantive. There's a variety of tests for whether a statute is substantive. One of those tests comes from Miranda Holmes, impairs a vested right, imposes a new obligation. Another test that Justice Scalia cites comes from Florida v. Miller, which creates new consequences. Even Justice Scalia himself proposes a new test of what's substantive.
Could you, and it seems like, and that, I think it would be a shame if this case ended up in getting the court even more tangled up in the substantive remedial distinction, whatever. But the first DCA did rely on remedial. It strikes me that if the case came down to is this substantive or is it remedial, it would be a much harder case. I mean, it seems like clearly there are new substantive obligations being imposed. Arguably, they, are remedial in the way the court has used that, in the sense that they essentially kind of help the bargain between the two parties kind of come to fruition. So they're new obligations that I would say are substantive, but they're consistent with the pre-existing obligations. But could you sort of give us your best argument as to why, under the framework as we've described it, why these should be deemed remedial? I mean, would you want us to affirm on the same reasoning that the first DCA adopted?
Let me answer it this way, Your Honor, if I can, with a minute left, is that we agree with the first DCA's finding that the act is remedial. But as both the majority and the dissent agreed, this is a tough question, right? It could go either way, whether the statute is remedial or substantive. What we're saying is that's not definitive in this case. Even if the statute is substantive, there's a second prong to the court's traditional test, and that is, does the statute violate a specific constitutional provision? Petitioners say that that property right is somehow defined in Miranda Holmes as, imposes a new obligation. What we're saying is that that statement from Miranda Holmes is the substantive test. It's the first prong of the analysis. It's the statutory interpretation. There still is no due process interest in that particular Miranda Holmes test or statement. There are no other questions. I see my time's expired. I appreciate it.
Thank you, Mr. Chief Justice, and may it please the Court. Since 1868, the Due Process Clause of the Florida Constitution has prohibited the state from depriving a person of life, liberty, or property without due process of law. The question in this case is whether that clause categorically prohibits the state from retroactively imposing new obligations or penalties on old contracts. At the outset, I want to clarify our position on how we think this analysis should unfold, because I think petitioners have taken the view that we would entirely eliminate due process review of retroactive civil retroactive civil laws, and that's incorrect. First, we've asked the court to reserve the question of vested rights at footnotes 4 and 5 of our brief, and even putting that reservation aside, we think that retroactivity can be challenged under the Contracts Clause, the Takings Clause, and the Due Process Clause. Where we depart from petitioner's theory is that we do not think that a retroactive law is impermissible merely because it imposes new substantive obligations or penalties. Instead, on our view, due process tests a retroactive law the same way as it tests any other law, with rational basis review. And I would hasten to add that our approach, therefore, would align the Florida courts with the federal standard, and the U.S. Supreme Court has said that that standard already prescribes, quote, harsh and oppressive laws.
It seems like you're sort of asking us to go back to the studs, but then with your footnote on and kind of waffling on the vested rights thing. I mean, isn't that sort of the whole ball game? I mean, because you can't say do rational basis review and then sort of think about vested rights later. I mean, am I wrong to understand the ball game in that regard, that if you keep some sense of vested rights that you're sort of no longer in rational basis world, and that there is, some substantive due process protection that's not as robust as what the other side is arguing for, but it still is more protective than rational basis review.
So I don't think that's wrong, and let me explain why we've asked for that reservation. Let me explain why I think it makes sense in the context of this case. So I just think that the historical record is much more robust, that there is some protection of vested rights than there is for obligations or penalties. I think that's a much harder question, and it's one that I don't think that the court needs to get into here, and where I direct the court is page 568 of the trial record, and that's where the trial court rejected petitioner's vested rights claim, and I don't think that they've ever tried to re-articulate that claim. If you look at their first DCA brief or their opening brief here, they never make a vested rights argument. It only comes up in the reply, and I think that that argument is therefore waived. So I think there's good reason to reserve the vested rights category in this case, because it's a much harder historical question, and it's a question that I just don't think that the court needs to answer. Instead, I think in this case, the court can answer the question of whether due process prohibits a state from enacting a law merely because it imposes new obligations or penalties. And on that question, I think the text, history, and structure are quite clear. So let me start with the text.
Could I just one clarification? What about a cause of action? Could a cause of action be a, quote, immediate fixed right of present or future enjoyment, unquote, or is it by its very nature incapable of being a vested right?
So I think if you look at the 1871 Cooley treatise that we cite, Judge Cooley does take the position that a cause of action can sometimes be a vested right, but it would need to be an accrued cause of action. I don't think petitioners have ever put forward a theory that they have an accrued cause of action here. So Justice Curiel, I think you asked my friend whether they could have a vested right in a cause of action to recover funds. I just don't think that replevin cause of action would accrued until they actually paid the funds, and here they haven't made a single allegation that they have an accrued cause of action. So I just don't think that's in the case. But if I can turn to the text, I think everyone agrees that there's nothing express in the due process clause that would prohibit retroactive civil litigation. Instead, the clause is quite clear that property or liberty can be taken away if due process of law is given. And I think, as the Justice Scalia citation in our brief makes quite clear, the question of what process is due in any given context is a question best answered by history and tradition.
So what's the source, though, even of the rationality requirement, though? I mean, it seems like if you just read it literally, you would just be asking, not in the case of executive action, but in the case of a law, you would just be asking, was there bicameralism and presentment and whatever? I mean, does just reading the text, does that, how does that even account for the rational basis review?
So that's an interesting question. Let me explain why we haven't gone into it, and then let me explain why I don't think you need to reach it here. So the reason we haven't got into it is because I just don't think it matters to the outcome of this case or really to any case. Because no matter what this court says about the due process protections provided by the state constitution, we're going to have the due process protections provided by the 14th Amendment. And the federal courts have said that you test these types of laws with rational basis review. So if this court said rational basis review entirely goes away, it would make a difference in literally no cases, because people would just bring those claims under the 14th Amendment. But I do think it's a much more interesting historical basis. So you can start to find sort of proto versions of rational basis review. There's a Michael McConnell article that discusses this in some depth, or into sort of the early 1800s. And so I just think it's a much harder historical debate that we haven't gotten into, because no matter what the result of this case, parties will always be able to be free to raise rational basis questions under the federal constitution.
Yeah, you can't just completely write off substantive due process as this thing that has no foundation in American law whatsoever. It seems like the fight here is just what's the nature of, what is it that's protected against, legislation. And it seems like we have all these categories, vested rights and, whatever, and it all it seems like a lot of it does come down to this kind of balancing. And I don't know, I know you're not arguing for it, and I don't know if we would make our jurisprudence any better by explicitly adopting nulls, but it seems like, the search for these sort of bright line kind of categories, that it's not historically grounded, and B, I'm not sure that it really gives you the sort of predictability and clarity that you would want.
I completely agree with that. I think there's a few points packed into that, and I'd like to untangle them because I think they're all important for what we're asking this court to do. So the first is, we think that due process of law has content, and we think that that content is largely informed by history and structure, and I'd like to go there. But on the question of nulls, I think a lot of the factors that Knowles is asking about are the very same factors that we would say are important to achieve on rational basis review. And so what I would ask the court to do is to clarify that rational basis review applies in this context, again, reserving vested rights, because that's a standard that courts already know and that they can draw substantial guidance from the federal courts, which have been doing rational basis review of civilly retroactive laws since at least Turner Elkhorn in the 70s. And it's a standard that is, Your Honor, Chief Justice Kennedy, you said in the Shands case, courts have been doing for all types of economic legislation. So we'd get rid of all of these rules that I think are confusing the courts on this and replace it with a standard that's well-worn.
How does Menendez come out, though, under rational basis?
Sure. So, I think it'd be an interesting question, and I think it'd be a question that would have to come up on an as-applied challenge, because what the federal courts say, if you sort of compare and contrast Turner Elkhorn and Eastern Atfel, where one's saying rational basis review survives and one they're saying rational basis review fails, we're going to look at what is the deprivation? Is it something that the parties could see coming? Is it something that's really severe, or is it tied in a rational way to the types of expectations that the parties had? I don't think there's any record in Menendez as to how that would play out. And the reason I think there's no record is because parties are sticking to the formalistic script that dates back to McCord. And that's a standard that I just think has no support in the history of the Due Process Clause. And I'd just like to highlight a couple things in the history. I don't want to entirely retrench our brief, but I think the striking feature of this case is that petitioners almost entirely cede the historical debate. They don't dispute that at common law, retroactivity was entirely permitted. They don't dispute that the 19th century cases and treatises permitted substantive retroactive obligations, and they don't dispute that this court's early cases routinely permitted laws that reach back in time to impose new obligations on transactions already complete. They've entirely ceded the historical debate, and I think it's actually quite striking. If you read through their briefs upside down and backwards, you will never find a single defense of McCord. The only thing that they tell you as reason to retain McCord is, first, they say that our rule would turn Florida into an outlier. I don't think that's true. We align the Florida jurisprudence with the federal courts, and the only source they cite to say we're an outlier is the Usman article. But that article characterizes McCord as taking a, quote, more aggressive approach that is joined by only a handful of states. And our submission on this point is that when text, structure, and history all point one way, this court should go that way and not the, quote, more aggressive way. And that leaves petitioners with a plea to stare decisis, but I don't think that stare decisis counsels in favor of retaining McCord. For the first reason, as Justice Muniz, you were quite clear, this court has not been consistent in applying McCord, and so I don't think that any party would reasonably rely on it. But for the second point, I don't think that petitioners themselves have said they've relied on McCord. They say they relied on the old insurance rules, but all of the tests that we would give them, due process, contracts clause, takings clause, would allow them to make case-specific reliance arguments. So I don't think there's any specific reliance on McCord. And for that reason, we'd ask this court to clarify that when the allegation is only that a new obligation or penalty is imposed, that claim should be tested with rational basis review. Thank you.
Thank you, Your Honors. A few quick points. I'll try to be as pointed as I can. First, just starting with Menendez, Justice Grosshans. I think you can read it, and you can keep reading it, and you can keep reading it. You'd never find the third step. You just never find the third step that they suggest. This is what it says. I'm reading straight from the page. In this case, we conclude the legislature intended for the statutory pre-notice provision to be applied retroactively. However, even where the legislature has expressly stated that a statute will have retroactive application, this court will reject such an application if the statute impairs vested rights, creates a new obligation, or imposes a new penalty. That's the standard. And it drops a footnote about impairments, but it doesn't say that this case involves impairments. It doesn't say that we further find that there's an impairment of the obligation of contracts. It proceeds to do the due process analysis. And that's it. And that's the standard. And that's the way the standard has been repeated over and over and over and over again. By the way, without much controversy, nobody has said there's something wrong with this standard. There have been a few disputes. There have been a lot of unanimous cases coming out both ways applying this standard.
Aside from the standards and the good legal discussion that's been had about these cases and so forth, the trouble I have with your case is because it's a facial challenge. The argument is on behalf of your clients that it places affirmative responsibilities that were not there before in the claims area. I see that argument. But it's difficult for me sitting here to determine, well, what other insurance companies may be out there that this does not provide any kind of additional responsibility on. Maybe they did it as a matter of policy themselves, and there's no additional differences between what they were doing to start with and what the statute's requiring. I sort of doubt that, but I don't know that. So, and that's the essence of a facial challenge, isn't it?
Well, I think what that sort of misunderstands a little bit what our facial challenge is, and maybe I can help clarify that. So our facial challenge is that if a law is substantive and creates a new substantive obligation, it can't be applied retroactively, as this court has said, to previous transactions, and this court has clearly said insurance contracts are done at the time of execution is what matters. That's what Austin says.
Except for in Lafayette. I mean, you have two cases. One of them looks to the day the contract was formed. Lafayette talks about accrual of causes of action. It didn't say it goes back to the day one of the policy. So we haven't even been consistent about that.
Yeah, but as you yourself pointed out in Lafayette penalizes conduct that wasn't wrong.
No, I
agree.
Right? I agree with you.
And this does too. This penalizes conduct that wasn't wrong. That's what this statute does. In the past, if we didn't do anything, if we didn't look, no penalties and no fines could be applied. Now penalties and fines get applied even if we don't do anything.
For your going forward conduct, which that gets into the whole thing about why are we even talking about retroactivity in this case. I mean, you're not going to be penalized. No one's going to come in and fine you because 20 years ago you didn't do a Death Master file search.
We're going to be penalized even if there's a partial match under circumstances where we wouldn't have any prior obligation to do anything. Even if we did voluntarily, and this is where I think you take on, you draw the facial challenge distinction. If somebody voluntarily, if the legislature passes a statute tomorrow that says everyone in the state of Florida who's walking out in public has to wear a hat. And it applies for the years 2020 forward. The fact that a lot of people wore hats does not mean it is not facially retroactive. The fact that just lots of people wore hats, when they go outside doesn't matter. You've changed a voluntary act into a statutory obligation. And once you've changed it into a statutory obligation, then to apply it to past transactions or past acts, that's uniformly, in every case, retroactive. That's the facial challenge.
Can you help us, though? I mean, and this gets to this kind of fundamental issue of what our court has said, and I completely understand why you're saying, look, we've parroted this test many times, and we can argue about how comparable the situations are. But it seems like there's an equally well-entrenched principle about not being entitled to the regulatory status quo. And what I don't understand is that given that, contracts are ubiquitous, contracts contemplate costs, et cetera, if we just mechanically apply your test and we look at the day that a contract was entered into and any possible regulatory change that imposes a new obligation that might change sort of the value or cost of the contract, how are you not essentially turning every new law that gets passed into a retroactivity due process violation?
Yeah, so because it's not merely about, and this goes to the heart of the conversation we've been having all day today, and I think my colleague pointed out the Connecticut Mutual case from the U.S. Supreme Court, which said Funds, he went through it pretty quickly, but listen carefully to the quote. Funds held in owing are not the insurance companies. That word owing tells you the whole story. Funds held in owing. That's why the payment trigger changes everything. Funds held are ours. Funds held in owing are the policyholders, the beneficiaries, right? And what this statute does is it says upon death, nothing else happens. Death. Nobody knows anything. Nobody searches the death master file. Nobody does anything. Boom. Those funds are now owing.
And I think that's interesting, but why isn't this a takings case then?
Maybe it could be, but it's also, I mean, it's a vested rights case.
And so clearly, though, I mean, if we're going to simplify things, that argument shows, I think, that the search and contact stuff is a dead loser. I mean,
it's
the
not
only thing that really we should be talking about is the escheat stuff.
Well, no, because the payment trigger is intertwined with the search obligations. And remember, if you don't undertake your search obligations, you get penalized. But you'll have to undertake your search obligations only because the payment trigger changed. So you can't separate them. It's both the escheat and the search obligations. And why it's not a takings case? Well, there's not public use. It's just taking it and they're saying
well, it is because the government wants the money.
But then any penalty, any
that's
change.
The whole thing. It's who's going to benefit from all this money, you or the state. That's what this case is about.
Well, not on the face of the statute. Not on the face of the statute.
There's two interests involved. There's getting the beneficiaries paid, and then there's the who's with all this money sitting around that's unclaimed. Or is the public going to benefit from it, or are you? Right?
I don't think that's exactly what the statute says. But admittedly, no doubt, there's a question about how soon the money is going to have to go to the state. By the way, it's how soon, largely, the money is going to have to go to the state, and whether the money goes to the state in some circumstances. But the point is, and this is really the heart of the argument. Heart of the argument. When you change when the money becomes held in owing, you've changed the property. You've changed the vested right that we have in the immediate fixed right, as Justice Curiel, as you said, immediate fixed right of present enjoyment. That's what it means for our pool of assets to be ours. And when you change it and you say, now we don't have a fixed right, we've got nothing, that's the change that affects vested rights. And unless you're going to take the dramatic step that even the state won't take and say, throw away vested rights, throw away penalties, throw away everything, you should reverse the district court's decision. Thank you for your patience. I appreciate your indulgence.
We thank you all for your arguments in this case today. The court will now stand in recess for about 10 minutes before we take up the next case.
All rise.